Okay. Christine Latos, can you unmute yourself? Ms. Latos, your case is not on our docket today. I'm not sure when it's on next. Are we able to check that?
I don't know that is so what she's here.
All right, well, she might be a witness then. Okay. Let's go to Bierboer, Jeffrey Bierboer, and Ashley Bierboer. And Ms. Hyde is on that case. And Mr. Hawkins is on that case. I guess I need to rely on the Mr. Hawkins as to where we're at right now. I know I changed the location for pickup when we were here last time. And I set this on to review, I think, to make sure everything was going okay. But
yeah, and I think we're just waiting on the guardian ad litem report as to the other issue.
Next, let's call Melissa Latos and Christine Latos. Mr. Lawrence is here. Let's see, is Christine Latos here? You know, getting a little bit of noise from there. Took care of it. All right, a couple things. Ms. Hilt, I guess you go by now. You brought a motion for evidentiary sanctions, and I just want you to know that would be held over to be handled by the trial judge. That would not be handled by me. And in particular, I know that you want the respondent to be prohibited from presenting any evidence or supplying witnesses regarding the questions contained in the interrogatories if she is not fully answered by April 2nd, 2023. That hasn't come up yet, so I don't know how I can make a decision on that request. So what you'll need to do before the hearing starts, is you'll want to make a motion to exclude evidence based on that motion that you brought. Okay.
On the day of the trial, I'm sorry, I'm trying to read the rules online and it's confusing for somebody who's not done this before. As I was looking at what they call, because today says it's pre-trial motions or does that, am I on the right?
Well, a pre-trial is not necessarily for motions. It's for the court to check in to make sure both parties are ready to proceed to trial.
Okay.
So the trial is set the week of April 10th. You have a readiness hearing on April 4th at 11:30. That's when you'll be given your specific judicial officer that will hear your case and the specific time during the week of April 10th. At that time, you may want to send to the judicial officer a copy of that motion and indicate that you'll want that heard prior to the hearing.
Okay. Really, my goal here is just to prevent any delays. That's really it. I just don't, I mean, we started this in December and it said 60 days on the piece of paper I filled out, and 4 months later, right? So that's it. Okay, I guess now is probably not the time, but so what are we specifically then doing here? Because this was set by the court.
Right. Again, it's for me to check in to make sure that there's that everybody is ready to go forward to the trial. And so it sounds like you're ready. Mr. Lawrence, any reason on your part why this can't proceed to trial on April 10th?
No, Your Honor.
Okay.
Okay,
And it looks like this Christine Letos is not here. But with the two of you, I think we're able to just say that we'll go forward and your next hearing will be April 4th at 11:30.
okay, thank you so much.
Okay, thank you. Latos and Latos, I know Miss Melissa Latos, I think you go by Miss Hiltz now. And Mr. Lawrence, you're in that case also?
Yes, Your Honor.
Okay. This is a motion for contempt, and I believe Miss Christine Latos is here. So Ms. Hiltz, do you want to start us off, and then we'll hear from Ms. Latos after that.
Sure. So I took in a motion for contempt, basically the last day of February, the first day of March, to again address child support issues from January and February, and then also to address the continuing concern regarding Christine's unwillingness to use the Talking Parents app in order to communicate. She keeps saying she can't. 2 years ago, I submitted a declaration showing the court that I had reached out attempting to solve the problem for her. And in that declaration, there was also an email address for support. I would have hoped she would have emailed them and figured out the problem, but it doesn't look like she has. And so that's what we're here for.
All right, and I know in February, we had a similar motion. I made a copy of that contempt order that I signed at that time, and the Talking Parents program was part of that motion also.
It was. This will be the third time going to court for contempt for Talking Parents. I'm really not sure how to address this. I can't that's not a legal argument. She has to, or she needs to find another solution, and she's not submitted anything to me or the court to show that she's made any effort at all to resolve this problem.
Okay, thank you. Ms. Latos, would you like to respond?
Yes, I've had problems with Talking Parents, and I apologize. There was a suggestion to use a different program, but we haven't moved forward on that. I don't know why. The program is loaded on my iPad, but Melissa hasn't given me her contact information for that second program. I'd have to go look at the name of it. I apologize. But it's the same story. I go into Talking Parents and it's just a blank page for me.
What kind of phone do you use?
I don't have a phone.
What do you have? Oh, you have an iPad?
Yeah, I use an
Or-
iPad. I have to go someplace where there's connection. Right now I'm at a library.
Is it so is it an Apple iPad or another kind of pad?
It's an older Apple, very old Apple iPad.
Okay, and so you don't have a phone service, it sounds like. So you use
No,
Wi-Fi with it.
Yes, I do. I use a Wi-Fi phone service.
Okay. What about child support payments?
They are being directly deducted from my paycheck. They're being garnished from my wages. I have less than $1,000 in the bank, so I currently can't pay her. So I'll have to take whatever penalty you give me. But I've spent 4.5 weeks in the hospital, so I've lost income this last January.
Ms. Heltz, do you receive child support payments from another source that is garnishing Ms. Leto's wages?
Child support enforcement attempts to garnish some kind of wages. They seem to be intermittent. They're not regular. In January and February, they were both $90 for each child, even though child support is, I think, $308 each kid. But it's been really, really inconsistent. Once last year, I got like an $800 or $900 payment, and then I'll go months at a time without seeing anything. It looks like she is doing some kind of work, but it's her job to get a real job if her income isn't sufficient. She has college degree. Her wages were $22.19 an hour, according to child support enforcement or the worksheets they submitted at trial. And I have personal knowledge that was probably less actually per hour than what she was making. I mean, we were married. If she's willfully underemployed, then that's on her. I would expect her to then start doing job search logs and to follow up with getting something that can actually pay for it. And I also wanted to make a statement about the one family wizard. I don't believe that she has downloaded it. The minimum payment to subscribe to that service is $150 for 1 year, or I think it's like $217 or $220 for 2 years. And so I mean, I find it suspicious that she's saying that she's paying for an app and she hasn't sent me an email or a text message or any type of communication asking me to give her contact details, nor have I changed my email address in about a decade.
So as I understand it, the child support owed each month is $308. Is that correct?
Per child. So
Per
I think
child. Okay.
yeah, I believe that's accurate. I submitted a supplemental declaration on the 20th because I got the support. The last 2 pages of that have the support distribution statements from the state, which is definitely, oh, I'm sorry, it's $304 per child. So it's a total of $608.
Okay, 608. And that goes through support enforcement. I guess the question is, isn't it up to them to enforce that and get judgments if it's not paid?
I have that same question, but they haven't done anything. It's been a couple of years, and this has been a consistent problem. I mean, really consistent problem, to the point where they call me and try and track her down. And I tell them I don't have any way to get a hold of her other than I can give them her email address. But again, I haven't been getting a lot of communication that way. Yeah.
All right. Go ahead.
I did notice there's a docket called a child support docket, and
There's
people.
a child support contempt docket.
How do you get someone on that?
I don't know that, but I'm gonna ask you to do a couple things after today. So I'm not denying your motion today, but I'm going to continue it because I want additional information from both people.
Okay.
All right. So Ms. Hiltz, I would like you to call at the Division of Child Support an attorney named Casey Looney, Looney.
Okay.
Indicate the issue that they are collecting child support, but it has not been paid. And I guess I would ask her if it's your job to obtain judgments for that, or whether child support will pursue it. And then the second question is, at what point do they require somebody to appear on the child support contempt docket so they can track payments? Ms. Lados, what I'd like from you is for you to file with the court about 3 months worth of wage stubs. You've indicated that your wages are being garnished. I would like to see proof of that.
Okay.
Before I make a decision in this case. Secondly, you said you downloaded some program, but you didn't know what the name was. And so I'd like you to, I guess, put in a short declaration saying what the name of that program was.
Okay.
If it's Our Family Wizard, if it's something else, I just want that information.
Okay.
Okay. Today is the 23rd. I would probably normally put this over 2 weeks, but I'm not going to be here. So I'm going to put this over to April 13th to obtain all of that information. Again, I'm not denying the contempt order, and I'm particularly concerned about the failure to use talking parents, because that's something that's come up before. And I think there's some obligation to figure out how to make it work. But I will give Ms. Lados some time to indicate what she has downloaded and see if we can get on to some program that's a family program, because there are certain benefits to that, certain protections for everybody, rather than just sending emails back and forth, which is a concern. And before we leave, Mr. Lawrence, anything you'd like to add?
Only one clarification, Your Honor.
Yes.
The week of April the 10th is the trial in this matter. And so does the court want to, I'm not sure if we're having our hearing on the 13th or not, whether or not the court wants to address in the middle of the trial this issue, or how do you want to proceed?
Well, regardless of where the trial goes, maybe the trial may address this contempt issue. I guess we could either leave it the 13th and don't let this determine your trial date. If the only trial date is the 13th, then we'll put this over. Or I could just set it the 20th now, and then we won't be in the way. Yeah, okay. Ms. Hiltz doesn't want that to happen. And again, my preference would be to do this on April 6th, but I'm not going to be here, and I think I need to continue to track this case. So let's set it the 13th, and then we'll see where it falls with respect to the trial. Go ahead, Ms. Hiltz.
Is there a reason we can't just put it over 1 week?
I'm not going to be here next Thursday either.
Okay, that's fair.
Yeah. And I think because I'm aware of this and I've entered previous contempt orders, it probably makes sense for me to hear it. So we have to go with Thursday the 13th.
That's fine.
Okay. And Mr. Lawrence, thanks for bringing up that it's a trial during that week. That is a consideration. Okay. I look forward to the information that you both provide, and we'll see you back here in 3 weeks. Okay.
Thank you so much.
All right. Thank you.
Good, we can go ahead and stay on the record and let me know when you're ready, and we'll see if we can get started again.
I'm ready. If you can
Okay,
hear me,
great.
I'm ready.
Okay, great. Thank you, Ms. Hiltz. All right, so I think we're in a similar position. We did some troubleshooting, not exactly sure why the audio is not as loud here in the courtroom as I would like it to be, but I've got the thumbs up from the clerk that it's adequate for purposes of recording of the hearing. So I think we're in a position where we can move forward. So we'll do just another formal start. This is the matter of Melissa Hiltz and Christine Litos, 19-3-44908. We're on today. There was a motion to modify a parenting plan, and also a motion within that is a relocation request. And I think that's to the Pennsylvania area. All right, so let me just double check to see who we have in the courtroom. Ms. Hiltz, you're here and you can hear me okay?
Yes, I am, and I can hear you.
Okay, great, thank you. And then it looks like there's a person, it says DV advocate, Hiltz case, Velarde. Could you tell me your name, please?
Yes, Kari Velarde.
Great. Ms. Velarde, are you here? Do you know the whereabouts of Ms. Christine Litos?
I do not.
Okay, all right, thank you.
Thank you.
Does anybody on the call have knowledge or whereabouts of the presence of Christine Litos? So I note for the record that on March 23rd, both parties were present and the matter was set over to, I believe, April 3rd. Let me just confirm this with my case file. Let's see, so we were here on the 23rd, and that was set over to April 13th. On April 4th, everybody was here for the readiness hearing. And the readiness hearing, that's where the court set a trial date for today, April 10th at 9 a.m. And well, actually, pardon me, Ms. Hiltz was present, Ms. Litos was not present, Mr. Lawrence was present. And so I guess that's where my concern comes, is that there was a hearing on the 23rd of March, and I'll just confirm this again. And Ms. Litos and Ms. Hiltz were both present, as well as Mr. Lawrence. And on that date, it was set, it says the court does not rule on the contempt. Court sets the matter over to April 13th at 9 a.m. And then on April 4th, which was previously set via scheduling order, Ms. Hiltz was present and Ms. Litos was not present. And that's where the court set the trial date to April 10th, today at 9 a.m. So I have some concern that Ms. Litos may think that the case was set to April 13th because of the action that took place on March 23rd. And maybe Ms. Hiltz, you can shed some light or perspective from your end, please.
I hope to, because I really didn't want this to be a problem. We really need to get this done. We've been trying to do this for 4 months, or at least I have. So in order to make sure that she was fully aware of the trial dates, I have sent her a text message, an email message, and a Facebook Messenger message in the last week, reminding her and letting her know that the trial was set today at this time. She hasn't responded to any of those messages.
Did they bounce back at all, or did they show that they were, so no bounce backs from those?
No bounce backs on the email. No way for me to tell if she's reading the text messages, and she has not read the Facebook Messenger messages.
Okay.
Those do remain unread. However, I replied to an email within moments after she sent me one. So she should have received it. She had been actively using that email address. And I hit reply, don't forget about April 10th, or was it trial next week? Or I don't have it immediately in front of me, but I've made a really strong effort to make sure she's here. Additionally, when we were talking about the contempt at court and the date for setting it over to the 13th, Mr. Lawrence brought up to the court that trial was set for that week. Christine was present during that conversation, so she was well aware, because we talked about it in open court, that the contempt was being held over for the same week that trial was being held over. And if for some reason there was a conflict on the 13th and the trial ended up on that date, that we would need to reschedule the contempt. And Christine was present for that. I don't expect her to respond or to show up. As you can see, she hasn't filed anything in this case with the court since 2021. All pleadings and responses have been from me.
Okay. All right, thank you. I appreciate that perspective. One thing I just wanted to just double check. So the 606 Columbia Street, Kelso, Washington, there's been, my understanding, that's been the kind of the status quo address for Ms. Litos. And to your knowledge, Ms. Hiltz, has there been a change of address filed with the court?
There has not. That's actually my brother's home. All of his rental property. He rents it out. It's a boarding house. She moved out of there December 31st of 2019. No less than a dozen times have I reminded her she has to file something with the court. You'll notice I did a motion to serve by mail. And I noticed in Odyssey that there was a return of service when they sent the trial notice to her, and then they resent it to the PO box in Tacoma. So she should have gotten notice, and that's where I've been serving her at. And it's also where I served all of her exhibits at. And she did send me a response to discovery on the 3rd or the 4th via email.
Okay, and the emails that you're talking about is it looks like crysletos@gmail. That's one, and the other is crysphone@gmail. Those are the ones you've used in the past, and you've had responses recently.
Correct. Recently, the responses have been from the crysphone@gmail. Previously with the court, she was using chrislitos@gmail. Although now that I look at it, I'm in my email right now. It looks like I've been getting responses from both email addresses. So,
Okay.
because her response was sent to me from the chrislitos@gmail on April 3rd at 9:30 a.m.
Okay. So the order regarding allowing for service was filed on January 20th, and that was the post office box in Tacoma.
It was, yes.
And was there a notice of that it wasn't able to be delivered there? Mail returned unclaimed, I think was the notice.
Yeah, the unclaimed was when you guys sent the notice to
Scheduling
606. The scheduling notice to 606 Columbia Street. When I serve by mail and I send one regular first class mail and then I send another one certified requiring a signature, she doesn't seem to be willing to sign the paper saying receive the one for signatures. So I do eventually get those back. I've gotten one packet back from December and one packet back from January, but the first class ones that are sent without needing signatures are not getting returned. Those are getting, those are staying there. And I can also see that on her pay stubs that she gave to me just recently this last week, it also lists the PO box in Tacoma, the same one that we are sending to the court. So
The post office box in Tacoma.
Yeah, on her
Okay.
pay stubs.
All right, and so that pay stub has the same post office box, same zip code as that you utilized in serving documents to her of the summons and the petition and all that.
That is correct, yes.
Okay. All right. Let me just view a couple of other items, make sure I'm comfortable where I'm at. Okay, so just one last check-in with the parties. Sometimes as a case goes on, some people have some difficulty logging in. So I'll just again call out the name Christine Litos. If you're here, please unmute, state your name. While we're waiting for a response there, I'll note that we're in courtroom 2. I believe the front door is locked. We are streaming live via YouTube, so we're comporting with the open court doctrine. There's nobody in the courtroom other than myself and Madam Clerk. So at this point, I'll find that Ms. Litos is not present. And since there has been adequate notice of today's trial, and there is a petition filed, I think I'll grant the petition. So I think that's where we're at.
Right, I was gonna say, and that was actually one of my questions, is if she doesn't show, what is there for me to do or to say? I mean, I don't.
Yeah, I mean, your petition has stated your request, and the request is to allow you to move to the Pennsylvania area to attend law school. And let's see, and then the parenting plan. Let me just double check. Ms. Heltz, do you recall you filed a motion for adequate cause back on December 13th. Was that formally ruled upon? Do you recall?
I don't know what that means. Motion for adequate cause, is that the contempt? That's not
Let's see the
contempt, no.
basis of that, or let's double check.
When you go pro se, sometimes you file funny things because you don't always figure it
Sure.
out exactly right.
Yeah, it looks like your motion for adequate cause filed on December 13th states that the basis that you filed a petition to change a parenting plan, and you asked the court to make a finding of adequate cause to allow the case to move forward. The other party was served. Indicated that Ms. Litos had not utilized parenting time for more than 17 months. So there was that motion.
Okay,
And to your knowledge, Ms. Hiltz, Ms. Litos has not filed any document in opposition to your requested relief of the intended relocation, the petition to modify, the motion for adequate cause.
correct. And I double checked Odyssey this morning to make sure nothing showed up Friday.
Right. Right. And I'm not seeing anything that she's filed in opposition. And so let me just double check to make sure we're on that motion for adequate cause. If there is an order related to that granting it.
I don't know if I did an order. I know I have one printed out here, but I don't know if I filed it figuring we'd do it. I don't really know.
Yeah, I'm not necessarily, it's not popping out. I see orders to show cause on a variety of issues since that time. I'm not in a specific motion or order related to that adequate cause. So let's go back to that then. On the December 13th, that's when the petition to modify the parenting plan was filed. There's also a notice of intended relocation with the children. There was a summons filed on that date. There was a motion for adequate cause filed. There's a proposed parenting plan, a supportive declaration, a notice of hearing, affidavit of mailing, all that happened. So it sounds like Ms. Litos has participated in some of the hearings, and some of the hearings she has not. And maybe Ms. Hiltz, you can inform me, was she in opposition to the move or the proposed petition to modify?
I think her statement was that she was okay with me moving as long as I would give her 2 weeks, 1 week visitations per year of unsupervised visitation. To which that's not going to happen.
Okay.
The current parenting plan allows for 3 hours a month of professionally supervised visits. And she hasn't used them at all. And so there's no way we're going to 2 1 week unsupervised parenting times without some kind of,
Okay, and is that in your proposed parenting plan? You list some limitations, you abandonment, neglect, and also concerns related to chemical dependency or substance use disorder and reunification. Decision-making, you have it as limited. Dispute resolution, you have yourself listed as custodian, and then a limited schedule for Ms. Litos. Basically says no contact with the other parent, except for what's listed in paragraph 4. And paragraph 4 says that she's to have supervised parenting time by a professional supervisor, no contact with the children at this point, but she has to complete the following: a chemical dependency assessment treatment, complete court-approved parenting class, begin reunification, family therapy prior to the children. Give petitioner at least 7 days advance notice before the first appointment, opportunity to provide collateral information to the evaluator. And then start and complete treatment as provided by an evaluation. And the court, Ms. Litos may not petition the court for visitation with children until such a time as she has completed the above recommendations. Okay.
So
All right.
basically what I did was took the old parenting plan in and added abandonment. All the other findings were done at trial. The abandonment's the new one. And then basically I didn't want to move to Pennsylvania and then be held in contempt because I couldn't make a visitation if she set up supervised visitation. On top of it, I don't think it's good for kids to not see a parent for 2 years, go through that mourning phase, and then have them have the opportunity to randomly show up and disrupt our life. After such a long period of absence, that's not healthy. That's,
Okay.
you know.
All right, thank you. Okay, so let me just systematically work through this. So with regard to the motion for adequate cause, there's been no formal response to that. Ms. Litos was given notice of today's hearing. She was present. There was an order setting a readiness hearing for April 4th, which she was present at that time. That's where the court set the. Pardon me, she was not here on the 4th. I misspoke. Yeah, so she was not here on that date. Yeah, so then I guess that order that sets the trial date is kind of a key piece there. There's a notice of a trial date that's dated March 2nd, 2023. That's where it lists the pretrial that would be heard on March 16th, a readiness hearing on April 4th, and then the trial is noted a week of April 10th as being that time frame. And that was sent to Ms. Litos at 606 Columbia Street, Kelso, Washington, 98626. Then that notice was returned to sender, unable to forward. And it says a copy has been forwarded to Ms. Litos at Post Office Box 5484, Tacoma, Washington, 98415. Ms. Hiltz indicates that that post office box is still a good post office box as manifested by a current pay stub that lists that same post office box for Ms. Litos. Ms. Hiltz, do you have a copy of that pay stub in your possession or in any of the pleadings?
They're not in the pleadings because I just received them, and I actually was, as soon as we're done here, I was going to compile them because it's relevant to the contempt for not paying child support that we're going to hear on Thursday.
Okay.
So the court will have them shortly.
Do you have them now?
I do have them now.
If you could find that and then share it with me. Either share it or just hold it up to the screen so I can look at it carefully.
Oh, it's backwards is forwards, forwards is backwards. Am I getting the right? Oh,
I'm seeing the
Melissa.
top right.
Yeah, it's because I'm having a fun time getting the camera. There we go. Aha.
Okay, can you back it up a little bit?
Yep.
Let's see, I'm dealing with this. I have to do it to the large screen. And then when I speak, it pulls up my face, which I don't want to see, but I want to see the document you're holding. So when you're holding up, I just need some noise coming from your end of things.
No problem. I can keep talking so that the camera focuses on me, and I can move forward to bring in the address here.
Okay, and can you read the address for me?
P.O. Box 5484, Tacoma, Washington.
And what's the date of the pay stub?
Oh, this one that you were looking at is a pay date of 12/23/22, but the most recent one I have is from March 3rd of this year. I just grabbed one of the sheets. She sent me 4 or 5.
And that pay stub from March 3rd, 2023, does it have the same post office box number?
It does. It has the same post office box number.
You could just pull it back a little bit. It's a little blurry.
Yeah, I know the blurry and the focus is fun.
Okay.
So, but yes, it has the same PO box.
And that, as far as your knowledge, that particular post office box, or pardon me, that particular employer, that job that she has, is that a job that she's had for how long roughly?
According to the interrogatories, the date you first, oh, that's first present. I thought it was somewhere in 2021.
Okay, okay, so she's.
Sorry, I
more-
didn't really go over her. Oh, October of 2021.
Okay, so about a year and a half.
Yeah, I mean, I did, you know, I figured I'd prep all the financial information before Thursday.
Okay, all right, so that notice of the trial date, it shows to the Kelso address, it was returned to sender, unable to forward, and it also indicated that it was sent to the post office box at 5484 in Tacoma. That notice of trial date indicates that on April 4th, there'd be a trial readiness hearing, and then the trial would be the week of April 10th. So then we look at the dates in which parties were present. We have a trial or a hearing date on March 23rd. This is a show cause contempt hearing related to, I believe, child support issues and failure to use the Talking Parents app. And at that time, the court did not rule on the contempt. It says Mr. Lawrence questioned the court regarding the week of April 10th, that's the trial, and not sure of the hearing on the 13th. So that's alluding to what you indicated before, Ms. Hiltz, is that there was some discussion related to that in that hearing. And then the court indicated the trial may address the contempt. And then discussion regarding the next review date, the court set that to April 13th at that time, it looks like. So and at that time, Ms. Litos was present. Then there was a motion filed regarding failure to comply with discovery on April 4th, of which Ms. Litos was notified via the trial scheduling order. The trial set the trial date for today, April 10th at 9 a.m. And she was not present on that date. So I think there's sufficient information to show that Ms. Litos was served with the trial scheduling order, which set April 4th as a date of a readiness hearing. She was present. She received that document by the indication that there's a post office box that's receiving a current pay stub, and pay stubs are generally accompanied by a check. So there's some good indication that she's receiving that information. The motion for adequate cause has not yet been addressed. There's been no formal response to that. So I'll make a finding of adequate cause based on the representations and the pleadings of Ms. Hiltz that there's been no visitation with the children and that there's chemical dependency concerns. So I'll make that finding that there is adequate cause. The motion or the petition to modify the parenting plan is tied to that adequate cause finding. So since there is adequate cause and that there has been a petition filed for a change of the parenting plan, I'll grant the petition to modify the parenting plan as proposed and submitted in the pleading from December 13. So that proposed parenting plan will be the one that the court adopts. The court also makes note of the notice of the intended relocation. The court knows that there's been no formal response to that. And so I'll grant that motion to relocate with the children. There is a presumption, obviously, with Ms. Hiltz being the primary custodial parent that she's permitted to move, and without any opposition, that's clear that that relocation should occur. The notice of each of those proposed parenting plans, the motion for adequate cause, the notice for relocations, the summons, the petition was captured through motions to serve by mail, and there was an order allowing service by mail. And that was filed on January 20th that allowed for a service at the post office box at 5484 Tacoma 98415. Again, that's the same post office box where Ms. Litos is receiving her pay stubs as recently as March 3rd and also prior on December 23rd, 2022. Those are the pay stub dates. And that the trial scheduling order was sent to that same post office box. It was not returned, no indication that it was returned within the file. So I think based on that, I'll make a fine, I'll grant the requested relief based on a default finding. And so Ms. Hills, so there's some proposed orders that I would ask that you file, and if you, I don't know, you may have already filed them. Have you filed proposed orders?
I'm not sure. You want to
Okay.
propose parenting plan or propose? I printed out things that I don't know that the clerk took because we weren't there yet. Is that the final order on findings and petition to change a parenting plan or custody order?
That would be one of them, yes.
So I have 2 copies here, so I might have filed one with the court. If not, I can bring another one down.
Yeah, we would need, I would need a some type of order that grants the petition to modify the parenting plan. So I'd need that. I would need, I think you mentioned the findings and conclusions related to that. And then I would need a final parenting plan that mirrors your proposed parenting plan.
Okay,
I would also need an order granting the adequate cause motion.
okay,
And I think that's it. I think that's it.
okay.
And having said that, as you're probably aware, defaults are not favored in the law. The law wants to resolve issues on their merits. So there may be, you know, I'll sign off on those orders that you present. There may be a motion to reverse the default based on concerns related to this April 14th date or April 13th date that was set in open court on March 23rd. So just be aware that that's a possibility.
Out of curiosity, how long does a party normally have to file a motion to reverse a default? Because this is how our last trial ended up too. It was a 3-day trial and then she didn't show, which she didn't. I'm more curious, I guess, is.
Yeah,
how
I'm
long
not
do I-
aware of a specific time frame that's
Okay.
outlined in either statute or case law. I think it tends to be case specific.
That's fine.
Okay.
I was just curious if there was a time when I could relax and go, okay, this is done, you know?
Right.
So, all right, thank you.
Yeah, when do you think that you'd be able to supply the court with those orders that we talked about?
I'm probably going to watch the last few minutes of this YouTube over and over again until I figure out exactly what you asked for and make it happen today. So.
Okay. All right, great. Okay, so we'll look forward to those. Once I receive those, I'll sign them and then I'll hand them back to the clerk and they'll be filed and they'll be available via Odyssey. At this point, Ms. Hiltz, do you have any questions or anything you want to review just before we end the call?
No, I don't think so.
Okay.
I mean,
All right, very good. Well, I'll look forward. Oh, one question I wanted to ask you is that you supplied some exhibits to the court for today's trial. Return.
if they want to give me the binder back when I show up, I'll take it. That's
The
great.
binder?
You know, if not, the rest of it can be shredded. So,
Okay.
or they can give me the whole thing, whatever.
Okay, we'll give you the binder back and the other ones that were supplied, which is just a mirror copy of those. We'll have the clerk destroy those, but we'll make sure you get the binder back. Okay.
All right.
All right, very good. All right, so with that, I think we'll go ahead and end the call today. Thank you for being present, Ms. Hiltz, and good luck with everything.
Thank you.
All right, Melissa Hiltz and Christine Latos. I see Miss Latos here. And Miss Hiltz is here. Just give me a moment. I'm pulling this up on my computer. All right, Ms. Hiltz, let me go to you. I know you were in court with Judge Evans recently, but I think we're here for child support at this point. Is that right?
Child support and then the Talking Parents app. We had court 3 weeks ago and you ordered Christine to file 3 months of pay stubs, indicate wages garnished, and to submit a declaration regarding the name of the app that she is attempting to use to communicate. And we held it over to today.
And I didn't see 3 months of wages, but I did see some wage statements and it did show a garnishment on that. Did you see that?
I'm the one who submitted that.
Oh,
She
you
didn't, yeah, she didn't submit anything to the court.
Okay.
She sent me a copy of the interrogatories for the trial that she missed on Monday. And in that included a mismatch of pay stubs. There are partial garnishments happening, which is part of it. It looks like they're garnishing around $180 a month, which fits with about what I've been getting. It seems to be hit and miss, but her income shows that she absolutely should be garnished more than that.
Actually, I think it's $180 every 2 weeks. So the pay periods go from 129 to 211. The other one.
Right. I did see that in the January statement, how there was 2 of them. However, I received 180 in January and then another 180 in February. So if the garnishments are behind by a week, any way you look at it, I'm not receiving it. And I'm not receiving it in a way that it's even close to what she should be paying. $180 a month instead of $608 a month is not sufficient, especially when she's taken 2 vacations so far since we started these proceedings 3 months ago.
Who are you receiving the money from?
Division of Child Support.
Okay.
And you'd asked me to call Miss Looney's office to talk about how we get onto the monthly child support contempt docket. And I have information on that too, if you want it.
All right, I did talk to her yesterday myself, but why don't you go ahead and discuss what you found out?
I learned that it's the caseworker assigned to person who is supposed to be paying. The caseworker is determined by the address of Christine. So, and then it's that social worker, when they have exhausted what they call all means, that then they can make a referral to the court. But that sounds like it would be in either King County or Pierce County, not here. They did suggest that I continue to do it privately, that I'm likely to get a swifter and stronger response from the court. But I could certainly follow up with her social worker and ask him to refer it to the Pierce or Tacoma, King County, so that they could start, threatening jail time or whatever it is that they do. So.
What is, and I'm sorry, I don't know this, but what is the monthly child support that's been ordered at this point?
608 plus daycare and medical at 53.3%.
Okay, so even at 360 a month, we're still about 200 some dollars shy, $240 shy of that.
Right, and it looks like she picked and chose the pay stubs to send me that were garnished, because there's a lot of missing ones in there. Like I didn't have any for February, I had 2 for January. There was like a December one, an October one, like it was really hit and miss what she sent me. And honestly, you look at it and she is working 80 hours a week plus overtime at $18 an hour. I mean, her monthly income for January was $3,200. There's no reason out of $3,200 that she's only sending $180 in child support. If her employer is not garnishing the full amount, it is her responsibility to make that up.
What amount are you asking for today? Have you calculated that?
Your Honor, she's behind by including the judgments by like almost 50 grand. I would take anything at this point. I mean, we have a $34,000 judgment that she hasn't paid a dime on, that's been accruing interest for a year and a half at a rate of $334 a month in interest. I just don't. The dollars I'm looking at are so overwhelming. I would love it if she made $1,000 a month payment, the $608 a month for child support with an additional $392 a month to start on the arrears, would be a great place to start.
Ms. Latos, any response?
Yes.
Go ahead.
I am currently looking for a better job, have a good job offer to hopefully get some money. Right now, my bank account is less than $200. I truly do pay what I can, but I really do need to find that better job. I'm not even getting 40 hours a week currently. So that's where I'm at. I gave all the pay stubs I had. I just found everything I could find and put them in chronological order and copied them and mailed them. Your office wouldn't receive them directly, so I had to certify mail them to you with a copy of my screenshot showing a couple different parenting apps that I could download that I had been exploring. Again, those were sent certified mail. I'm currently in Nevada trying to find a job, so I don't have access to my Washington Post for the past couple days, but I'll be back within the week.
I realize she claims she's in Nevada looking for a job, but sending papers from Las Vegas indicates she's on vacation.
I'm a poker dealer. I'm trying to find a poker job for the World Series. I got a job offer from Caesars, but I have to wait for all the background information to come through.
All right. You acknowledge that the current child support order says $608 a month.
That is correct.
I think
I missed
$304 per child, right?
Right. I missed that trial date. I wasn't able to represent myself. Melissa got everything she wanted at that time without any type of negotiations. She just got her way.
Well, but you weren't present.
Yeah, I know. I wasn't present. I was in the courthouse, but I couldn't get on Zoom. So at the time I was just out of luck. So I didn't know how to proceed from there. I really don't know how to proceed from here.
And you have not worked out using Talking Parents yet as an app to—
I haven't. I get in there and it's just blank. I don't.
Have you gone to anyone to try to make it work?
Gone to anyone? I've sent a
Have
request
you
to
gone
their.
to a computer store or?
Oh no, I haven't tried that. No, I haven't. When I get back home, I have actually a friend that does a computer store.
Well, this is the, what, 5th month that we've been discussing this. It seems to me that should have been done long before today.
Okay, I apologize.
Your Honor, the first time she was held in contempt for this in the same month 2 years ago, she stated in her declaration that she was going to see this same friend, his name is Nate, in Tacoma, who works in IT, and that he was going to help her
Nate
figure
passed
it
away.
out. The
Wow.
reality is I'm very sorry to hear that. The reality is she keeps saying she's going to do it, but not doing it. It's been 2 years this month.
I know. That's come up. Just give me a moment here. I want to look at my last contempt order. All right, I think my last contempt order was on February 9th. And I ordered past due child support of $3,135, past due medical of $563.49, a civil penalty of $500, and no attorney fees. Excuse me, a daycare expense of $1,165.94. I'm not sure what all that adds up to. We're back here today on two issues, and that is the full child support has not been paid. I do acknowledge there's been payments through a garnishment, but those do not completely satisfy it. And secondly, we're still dealing with a failure to use the parenting app. And Ms. Latos has been given multiple opportunities to try to get that to work, and it sounds like she hasn't really asked anybody to assist her to do that. So I'm going to find that there is contempt both on the parenting app and on the child support. Ms. Hiltz, I want you to prepare an order. I don't have one in the file. So the order would indicate whatever child support is due since February 9th, less any amounts paid through a garnishment. And the civil penalty, we did $500 last time to try to get the parenting app in place. That didn't work. So the civil penalty this time will be $750.
Is there a time frame on paying those? Like, if she's gotten a lot of judgments and penalties, but I've not ever actually seen any of the money from any of them, nor have I figured out what I do to get it. Is there a time frame on those? And then is the next step then to file another contempt for not paying the contempt?
Well, I don't know that you can get a contempt on a contempt. And what you have is a judgment. And so you can enforce that through ways that judgments are enforced. This is going to be a little bit more complicated because Ms. Latos is working in Nevada. So you'd have to have a judgment entered in the Nevada courts. And then whatever tools Nevada allows, garnishments or some other ways, could be utilized at that point. Okay. I know these judgments are building up, but the tools available are the tools to collect a judgment.
Okay, that's fair enough for me to figure out.
Okay. So if you prepare that order, that gets us then to April 13th. I want to set a review in this case for a month from now, and it's to specifically to check in with Ms. Latos as to her work status. And if you do have a new job, then I want to make sure that Child Support Division knows about it, and I want to make sure that Ms. Hiltz knows about it. Okay. So
is there excuse me, I'm sorry
go
to
ahead.
interrupt. Is there somebody I can contact when I get my first paycheck so that we can expedite this process to getting it, so it doesn't push out several months?
I would call the Longview Child Support Division.
Okay.
You could talk to Ms. Looney or Ms. Powers. And
that's 2 O's, Looney?
yes. Or Ms. Powers.
Okay.
And give them the information, and then they will they'll take it from there in terms of putting another wage garnishment in place.
Excellent.
I I'd like to set a hearing then for May 11th. That's a Thursday at 9 o'clock. To just check on the status of Ms. Lato's employment at that time.
And one more question.
Sure.
Since I am not objecting to her going to college, this in no way restricts her from getting housing and getting to college, correct? She can go to Massachusetts and get her education.
Judge Evans approved of all of that.
Perfect,
at the
perfect,
hearing
okay.
That you did not attend. So she's
I showed up on Thursday
okay,
instead of Monday.
she's clear to do all of that.
Your Honor,
Excellent, excellent.
And let me just maybe take that one step further. That also does not change the orders that apply to you. Okay. Ms. Late-
Understood.
Okay, Ms. Hiltz.
the 11th, I have a conflict.
Okay,
Can we go the 4th or the 18th of May?
do you think you'll have the new job by the 4th?
Oh, I sure hope so. I don't have enough money otherwise.
Okay, all right, then let's make it May 4th at 9 o'clock. May 11th was not a hard and fast date. It was just going out a few weeks. All right,
Perfect.
we'll see you both back here then on May 4th, okay?
Okay, have a great day.
All right, thank you.